Good morning. On 9/2/2012 at about 9:18 p.m., a cinema type crime was enacted. Accused persons while traveling in a car by sudden break reached one girl, Saraswati, and took inside the car, and thereafter she was found dead. Prosecution against accused were filed for offences under section 302 read with 34, 365 read with 34, 367 read with 34, 360, 376 2G, 304 read with 34, 201 read with 34, and they were sentenced for various offences, and the death sentence was also awarded by the lower court. High Court confirmed the death. As I have already told, the trial commences from the Sessions Court if the death sentence is awarded. That case went to Supreme Court, and Supreme Court acquitted the appellants for so many reasons. So I want to take you for all these ratios. They say no TA parade was conducted. Therefore, identity of accused was not established. Then they say non-examination of beat constable created doubts in arrest of the accused person. That was also considered by the Supreme Court, disbelieving the evidence of arrest of the accused as well as seizure of the vehicle. Then the copy of DD number 24 was crucial piece of evidence that said document was not exhibited as evidence by prosecution, which may prove that as to how and when they reached the spot where dead body of victim was found lying. Then 27 Evidence Act recovery with section 8 of the Act. The entire disclosure statement nature of confession recorded police officer trial exhibiting entire disclosure accused recorded by being read in evidence erroneous. That means the lower court did not understand section 27 and 25 of the Indian Evidence Act. That is unfortunate, and also section 8 of the Evidence Act. Then they say recovery of incriminating materials, broken piece of bumper, wallet, that were not proved. The cell phone and transactions between the accused and other witnesses since not been proved, call record under section 65B of the Evidence Act. That means either they should say that it was I who recorded the evidence, or you must say that it was genuinely recorded and nothing was tampered with. This is this. Then they say the postmortem report was also not clear about timing as to when death had occurred. This is too unfortunate. Then they say the case of bloodstains, cements found on seat covers of Indica car is sent to CFSL Forensic Laboratory was considered as unreliable. They say it is highly improbable. Then another, this is very important, because the Supreme Court says examination of senior scientific officer of CFSL and his report regarding DNA profile is itself is not sufficient. That was they say. So that was disbelieved, saying that in the absence of evidence that techniques was really reliably applied by expert should be proved. Otherwise, forensic evidence was report was not reliable, they say. So it is not necessary, not only necessary that a forensic officer be examined and DNA profile is being filed. They say you have to give evidence that what techniques, reliable techniques was applied to find out the DNA. So they have given benefit of doubt and acquitted all the accused. So probably the judgment may be helpful. Multi number of pages. It is AAR 2022, Supreme Court 5661, Rahul versus State of Delhi. This is case. The case was acquitted. Apart from all the other ratios which all are available in other judgments, this DNA proof would definitely help us to, because multi number of cases DNA is applied, particularly in POCSO cases. So my learned friends may concentrate on this judgment, keep this judgment on file and apply it before the POCSO court, wherein Supreme Court has held that DNA profile report and the evidence of senior scientific officer alone is not sufficient. They have to prove before the court that this DNA report was obtained with a high technical method. I hope you understand. Best wishes.